All right, everybody. Good afternoon, and welcome to the Return to the Vault for December, our legislative update for real property practitioners 2024, and always one of my favorite Return to the Vault programs on an annual basis. As always, my name is Matt Waters. I'm an attorney at Jordan Price Law Firm in Raleigh, the immediate past chair of the real property section, and also co-chair of this Return to the Vault program, along with Kyle Smalling, who is with us. Kyle, if you want to unmute.
Hey, everybody. Excited to be here as well. Look forward to hearing from Nancy. Hope everybody.
Yes, as always, we have Nancy with us, Nancy Ferguson, Vice President and Senior State Counsel with Chicago Title. There's been a lot going on down at the legislature this session, and we're thrilled to have Nancy with us once again for this very important program. As always, just a couple quick disclaimers and announcements. This is the Return to the Vault program. If you're new to this program and have not attended one of these with us before, this is a program created a couple years ago as sort of our way to re-engage and reconnect as we emerged out of the pandemic, and it's become a useful tool, we think, for our section to spread information and to gather together as we once did down in the deed vaults. These are monthly 1-hour programs on the second Wednesday of each month at noon. These are all recorded. They're not offered for CLE content or credit. However, they are all saved on our section webpage on the communities page. And so you can access all of these programs at any time by visiting that page. Quick programming announcements here. Be on the lookout potentially for a January 8th Return to the Vault program, still TBD. February 8th at 1 p.m., the Utah Hockey Club versus Carolina Hurricanes hockey game. So this will be our third year in a row that we're doing this Carolina Hurricanes hockey game and pregame tailgate. The pregame tailgate this year is sponsored by Old Republic Title. You all may have seen already the link that went out for the drawing for the tickets. If you did not see that, please email me or Kyle. You see our names and email addresses there at the bottom of this page. And we can make sure that you do get that link to enter the drawing. Now, all of you here, if you also enter the drawing for the tickets, that will give you 2 chances to win. And so we'll draw roughly 25 tickets. Or at least as many names, 25 names, or at least as many names until we exhaust the roughly 50 tickets or so that we have for our block. Each winner has the option to pick either 1 or 2 tickets. If you pick 2, you can bring a guest, of course. February 21st next year, the Real Property Hot Topics CLE program. And then, of course, in May, our annual meeting in Kiowa. And so we hope to see you all there. Wanted to just remind everybody again where this Enterprise Justice Odyssey Tips and Tricks toolbox can be found. Remember the nclta.org website for the land title is our repository for all things Odyssey and Enterprise Justice. The 2 programs that we've hosted this fall, presented by Terry Bowling, and her manuscripts and other helpful information that you may find useful for your use of the portal and the Odyssey product can be found at that webpage. You do not have to be a NCLTA member to view that content, which is also a great benefit provided by Land Title. So we appreciate that partnership with Land Title. Want to thank today's sponsor, Chicago Title. 20 lucky attendees in this program today will each receive a $25 gift card courtesy of Chicago Title. And I want to introduce Nancy Ferguson, our speaker for today. Of course, Nancy needs no introduction. You all know her very well, but again, she's Vice President and Senior State Counsel for Chicago Title, and she is the backbone of our section and does so much for us, and constantly monitors what's going on down on Jones Street in downtown Raleigh at the General Assembly. And so we are thrilled to have Nancy here with us today. So Nancy, I'm going to stop sharing my screen here so that you can pull your PowerPoint up. I can figure out the best way to do that. All right, Nancy, you should be good to go.
Okay, So it's going to let me share. No, I wasn't quite prepared for that, was I? Sorry.
That's okay. If you want me to pull up the slides, I can do that, and you could just tell me to advance the slides if that's easier.
And I'm just trying to get it on the right thing. Sorry, I have trouble getting it on the right screen. Is it coming up?
Yes. So it's
Okay.
at the programming announcement slide. So just advance, I guess, a couple more, and you'll be right there.
Okay, because it moved it away from my camera, which is what I was afraid of. Sorry. So I'm gonna take my picture off.
Okay.
Okay. Interestingly enough, I appreciate all of you showing up today because we ended up having two conflicts, one of which is Terry Bowling has given a great presentation again to a group of attorneys down east who are worried about what's about to happen to them, which is the imposition of Odyssey down east. And I will tell you that we've had quite a few examples where all of you who've already transitioned know it is not like VCAP. It is not at all like VCAP in so many ways. So we're seeing a lot more of people finding that out the hard way. So what I'm going to do, you know that our legislature works in a 2-year cycle. So 2023 was the long session, and 2024 is the short session to close it out. Now, when Hurricane Helene came, that kind of threw changes for everybody in ways that we are only beginning to calculate, but it certainly affected what is happening at the legislature. So some of these slides, I'm not really going to talk about disaster relief, but I am going to talk about the bills that happen to include disaster relief, among other things. So I just wanted to let you know, if this seems like it's an overlapping thing, it's because it's a 2-year cycle, and a lot of what happened in 2023 is now being cleaned up in 2024. I'll also tell you that there's going to be some hot off the presses or not even on the presses information I'm about to give you, because I just got off another land records call and have updates on several things from that as well. So I'm just going to truck on through now. And I can't see the chat anymore, Matt, so you may have to just interrupt me if something pops up that you feel like I need to answer.
Yeah, absolutely. That's a great reminder. Thanks, Nancy. Everybody here, please feel free to use the chat, whether it's to ask a question, say hello, or whatever you want to use it for. And we want you to use that for your participation and your use.
Yep, absolutely. And if I can't answer it, I'll do it after the fact. And there's our website, and my email address, by the way, is nancy.ferguson@ctt.com. And there's a link on our website. That may come back. Okay, today, like right now, first, the NC Bar Association Legislative Advisory Committee is meeting like right now, looking at what legislation the Bar Association may sponsor for the upcoming year. A couple of those things I'm not really going to mention totally because they're planned. They're not even introduced yet. But for example, one of them is the Uniform Electronic Wills Act, North Carolina's version. That's already been through estate planning. It's been vetted with real property and some others. It has been through the General Statutes Commission. So that's one of the things that's coming up. Another thing that they will be looking at today is on this slide. So the most recent, and I'm going chronologically backwards, The most recent legislative initiative that deals with real property, and a lot of these bills have a lot of things in them, and I'm not talking about anything unless it relates to real property. I'm staying away from a lot of other things. But Senate Bill 382 was passed when the legislature was in just a couple weeks ago. It was vetoed. It was overridden. The veto was overridden in the Senate. And today, or I guess this week, this legislative session is supposed to be these 3 days, 11, 12, and 13. The House will be reconsidering it. It includes some disaster relief provisions. It says it does. It's the first 13 or so pages. It includes Section 2E, includes some changes to the Consumer Finance Act. Like I said, it's 132 pages, so I've given you the section numbers here, so if you're interested in these issues, you can look. It also includes a curative for the Emergency Video Notarization Act because, and we'll get to that in a few minutes, that was set to expire June 30th of 2024. It was renewed, but there was a gap. And that gap is to be filled just in case anyone between July 1 and September 8th of 2024 did an emergency video notarization, a remote notarization in North Carolina, then this provision, Section 2E.5, was intended to fill that gap and to basically validate those notarizations that were done in that gap period. The firestorm that's lit and that's with the Legislative Advisory Committee today is Section 3K. It landed on Senate Bill 382 at the very last minute. And basically, it's very short, but basically what it says is that local governments can't downzone without consent of all property owners affected, all, 100%. And downzoning is very broadly defined. This is a provision that's going to keep some zoning ordinances that were already set up and ready to go from being able to be implemented. As you can imagine, that means this could effectively never happen because you never get 100%. We've always had that trouble. Anyway, but those of you that are concerned about any kind of zoning issues, then you'll want to look at Section 3K. And again, the bar is going to probably do something. The land use section's already working on that. And by the way, write this down. You can always go to ncleg.gov, and that's where you can find any of these bills. You can find out calendars. You can find out who senators and legislators are, where they're from, just anything you can imagine, including the General Statutes Commission and committee meetings, most of which are streaming live. So we'll wait to hear what happens later today on Senate Bill 382 and on what the Bar Association does on Legislative Advisory Committee. Whoops. I'm not going to say much about federal issues, federal changes. You all know we just had an election. I think we don't even know the extent of the changes that are going to come that will affect real estate. You know, there's a movement against the CFPB, and whether you agree with them or not, the issue is right now you use closing disclosures for residential transactions. So what's going to happen? Are we going to have to go through another change? They're looking at easing a lot of the safeguards that were enacted in response to the Great Recession. Some of the banks are very happy about that. There is a federal, CFIUS, federal foreign adversary rules, and we'll talk about those on a local level shortly, but that's a big issue for you guys because it's going to affect closings. There are new anti-money laundering rules. Are they going to stay in effect? Are they going to be changed? That's a big issue for both parties. You've already probably heard about the beneficial ownership and the CTA, the Corporate Transparency Act, and the Texas case. We'll talk about that in a minute. IRS rules. What's going to change there? Is 1031 suddenly going to be under attack again? and construction economics. You're seeing a lot of the press from the builders associations and the realtors about what's going to happen with a lot of the proposed changes by the incoming administration. Those are all federal issues. I don't have a crystal ball. I don't think any of us can. And I'm not going to be able to cover most of those because of that. So January should be a very interesting month. So what did just happen? Senate Bill 445 was passed, vetoed, passed again, and it has several issues in it that are of concern to real property people. And two of them, interestingly enough, are the ones that we see a lot as far as we're starting to see a lot more of these sort of fraudulent transactions. One is an increased penalty for willful and wanton damage to residential real property of another. That's a new implementation, Class I felony. The other, which is probably near and dear to title attorneys, is a prohibition on fraudulent rental or lease of property or fraudulent advertising of residential real estate for sale, knowing that the purported seller has no legal title or authority to sell. The punishments, Section A is a Class H felony. Section B is a Class I felony. In addition, it offers treble damages for any situation where they knowingly rented or leased residential property to another, knowing the renter or lessor had no lawful ownership. You'll notice they didn't put treble damages on the fraudulent advertising for sale. I don't know the reason for that. I can guess, but this statute is there at least if it's a fraudulent rental or lease, and even for the fraudulent advertising. I'm going to talk about deed fraud again in a few minutes. Senate Bill 166 contained a lot of things. I'm not going to go, I wouldn't even be competent to go into any detail on them, other than it deals with development regulations, state building codes, construction contractors, design professional regulations, and environmental health regulations, all dealing with the building code and the building code council. It was vetoed, but the veto was overridden, so it is Session Law 2024 at 49. This is one we've had a long time in coming, House Bill 556. It's another one that came in, had some provisions that were of concern, but it has finally passed. And it contains the tenancy in common provisions that have been drafted between estate planning and real property. If any of you have been following that, it was Senate Bill 217, I believe, before. That didn't make crossover, but this went through the General Statutes Commission. And again, it was vetted with the sections of the bar, and it was sponsored by the Bar Association or on our legislative agenda. And it has now passed. You may remember in the last few years, we've had a new article in Chapter 41 for tenants by the entirety, and we had a new article in Chapter 41 for joint tenancy. And now we have a new comprehensive statutory enactment of tenancy in common. And that includes a presumption of equal interests, how you deal with rents, profits, and responsibilities and obligations, adverse possession, and ouster. This is now statutory, not just case law. So any of us practitioners, we're going to want to look at that and at least know it's there. While we're here on a little different issue, I'll point out that in the joint tenancy with right of survivorship statute, when that statute was enacted a couple years ago, one thing it did was pick up that the deed would need to be from the grantor to whoever the joint tenants are, all of them. There was a time period in between that statute and the prior statute amendment where it had allowed that, for example, I could convey to my friend Sally for us to hold as joint tenants with right of survivorship and only name her as the grantee. Statute doesn't say that now. Joint tenant statute now still goes back to the old version where I have to convey to 2 or more people. So for me to remain a joint tenant, I have to name myself as a grantee as well, arguably. So that's one of those things we've pointed out to see if we need to get a clarification of that statute to revert back to what it has been for the past few years. Second thing and important, told you a few minutes ago, Senate Bill 382 has a curative if it's actually enacted. But there was the extension of the Emergency Video Notarization Act. That was, I think, September 8th was when this bill was finally enacted, finally effective. It also has several technical corrections to the notarial statutes. Now, I'm going to tell you hot off the presses, everybody listening, everybody that cares about remote notarization. We are waiting, as you know, for the third phase of the rulemaking on the Remote Electronic Notary Act. You all know this is a remote electronic notary. We will not have a remote paper notary statute anymore once RENA takes effect. And the proposed rules have been drafted for phase 3. Oops. And they are expected to be published in the NC Register on January 2nd, 2025. Again, this is hot off the presses, just learned this a few minutes ago. So January 2nd, 2025, they'll go public. They will be on the proposed rules, and they will be on the Secretary of State's website for comment, just like phases 1 and phase 2 were. The public comment period will be January 2nd through March 3rd. There will be a public hearing on February 4th, 2025 at the Secretary of State's office on Atlantic Avenue in Raleigh, February 4th. This will deal with all the technologies and the licensure of all the solution providers that will be approved by the Secretary of State for e-notaries. And e-notaries will be able to do remote. There is only one type of e-notary, and there is only one type of remote notary, and that's electronic. They will be fully effective by the time the statute set, which was July 1, 2025. They already have a fiscal note approved by the OSBM. There's going to be an informational meeting January 14, 2025. This is informational only. It's not required, but it's by the statute or for anyone to attend. It just is informational meeting for anyone that's interested. That's January 14th, 2025. Secretary of State will be doing new materials, new instruction manuals, etc. And they're going to deal with the fact that a lot of e-notaries will want to be remote notaries, and they'll have to have that separate training. And they'll also be having to train and set up the protocols for solution providers. So those are your dates. January 2nd, publish of the rules. January 14th, informational meeting. February 4th is the public hearing, and that is required by statute. March 3rd is the end of the comment period. And then they will finalize the rule, do all the publication, do all the training, so that everything will be fully effective July 1, 2025. Back to House Bill 556. It also has some local rent control provisions. This was what was the reason for the veto, because it had a requirement that local governments could not require landlords to accept subsidized tenants. Senate Bill 607 is another very long bill, but it includes a couple of things of importance. One is if you live up in Spruce Pine primarily, but there's another quartz mine, I think it's outside of Oxford, so it's down east. This statute prohibits any quartz mining operations or land containing a commercially valuable amount of high purity quartz from being sold to an entity that is owned or controlled by an adversarial foreign government. This statute is already in effect. It primarily is focused on the high purity quartz mines that are up in Spruce Pines. But like I said, there's apparently another one that's further down east. It refers to the federal statute, and though it refers to the old statute, these are, at this point, the 6 foreign adversarial governments in the federal statute it references or intends to reference. That may change. That's federal law. And there's your federal reference, 15 CFR. It's actually 791.4. It changed almost simultaneously with Senate Bill 607. These 5 are important: China, Cuba, Iran, Korea, North Korea, Russia, and the Venezuelan Maduro regime, because they're going to come up again in a minute. And that's already in effect. Senate Bill 607 also had several other provisions in it of interest to real estate people. There were quite a few CAMA and coastal area provisions, which have now been amended twice already. Well, if Senate Bill 382 passes. So just know they're there. This was a hot button. Section 22 was a hot button for the tax offices. It requires a tax collector shall, in addition to the advertisements required by this section, which is for delinquent taxes, also advertise a tax lien by posting a notice of the lien in a conspicuous manner at the parcel to be advertised. The reason this matters is this is the initial posting of delinquent taxes. This is not after time has gone by and they haven't been paid for a few months and then they're going to go and enforce them. This is the initial posting. And the tax offices, everyone I heard from, were like, we don't have the manpower. We don't have the sheriff's office people. We don't have the security to be going and posting notices in January for delinquent taxes. Some of you may have heard, and we're going to talk about this again in a minute, of the situation in Raleigh where a dentist's $4 million house was the subject of a deed fraud, and it's still going on, very highly publicized. And it was one where the fraudster decided to, and she's been indicted, or arrested, decided that she could claim title to the property because there had been a publication that the house was in, had delinquent taxes and was in tax foreclosure. So she felt like she had the right to go and claim title to it. Just saying. These things do have consequences. Senate Bill 802. For those of you who do commercial real property, you're really going to want to look at this. This is a statewide Commercial Property Assessed Capital Expenditure, or CPACE Act. Why does it matter? It's not just another deed of trust. This is a super priority financing. The financing is from private entities, but it's collected through the tax department. A lot of your counties have different types of assessments, and you can think for yourself how complicated sometimes it is to find out what these extraneous things are: hotel taxes, water bills, any other type of extraneous type of charges that cities and counties collect. Sometimes it's hard to get that information. These will be shown through the tax office. There's a program toolkit, comprehensive set of documents that's being developed through the NC Department of Commerce. At this point, we don't know who's working on it actually. We don't know that those documents will be anything like anything we've ever seen. Will they be recorded the way we would find them in the Register of Deeds vault? Will they be findable? How will you find that lender to be able to ask them if there's a balance? And the statute actually allows that they can have a provision in there that these would never be called forward. So it could be a really challenging thing to have, but it provides for qualifying improvements for energy efficiency, water conservation, renewable energy, and it does require existing lender consent since they're going to lose priority. There are several more of these that are in here. When you look at this, if you want to find them, you can look at them. I want to use my time effectively and move forward. Senate Bill 790 was the bill that changed a lot about how the state bar is running. You've seen a lot of new rules and charges, et cetera, and that's where it comes from. Land surveyors are now protected coming on land. I will tell you, one of the fraud situations we saw was where the owner of the land saw a surveyor on their own property and went out to ask about it. And the surveyor said, well, it was about to close the next day. A fraudulent seller was trying to close the transaction. Note to attorneys, if there's any discrepancy between the people that are on the tax bill and their address, always double check if you don't feel comfortable about it. We've had several that were caught precisely because the attorneys were cautious, saw the discrepancy, contacted the people on the tax bill, and found out it was a fraud. This unfair real estate agreements was the MV Realty case. It was one of the cases. The statute is in effect, and it has been for quite some time now. It provides that agreements that are in effect for more than a year run with the land on residential real estate allow assignment without notice or consent of the owner or buyer. Assignment by the potential purchaser, well, by the, yeah, and creates a lien or security instrument. The MV Realty situation were contracts that would be perpetual listing contracts for 40 years, listing contracts with a real estate brokerage out of Florida. So that's the point of this. That made no sense. That doesn't run with the land in 40 years versus 1 year, which is normally sufficient. But the exemptions are contract for deed, HOAs, lease with option to purchase, the things that have other statutory protections and rational reasons without overburdening owners. We've already talked briefly about remote electronic notarization. There's a lot out there, and especially the Secretary of State's website where they have all the public comment, et cetera. These are the notes from the old comment, but again, we now know that phase 3 is going to come January 2nd. And that's where you'll find the information. Canada joined the Hague Convention, so did China, for those of you who have notarial issues in other countries. That means that you can get apostilles, which is great, but still better to go to the U.S. consulate if at all possible. And always talk to your title company ahead of time. Whoops. In the Appropriations Act here, you'll see this is where, again, a lot of the new state bar rules came from that because the legislature really dove in hard on the state bar. It did say the state bar dues were not to exceed $325. It said district dues would be $90, but they went in for the curative later, which we talked about a few minutes ago, to say, no, they shall be no more than $90 because most district dues are not nearly that much. Farm Act includes timber larceny. Business Corporation Act, there were some changes in Senate Bill 477. There are several more on the Bar Association's LAC proposal, which they're talking about today. So you may want to look out for those. They're modernizing some of the old provisions of our Corporation Act. This one I want to make sure you know about. This is not Corporate Transparency Act. This is different. FinCEN has published a rule, and the rule has been passed already, So FinCEN has published a rule that for residential transactions, and that's going to be a defined term, which are either for cash or don't include a non-anti-money laundering lender, meaning don't include, for example, a bank lender who would be doing all the anti-money laundering due diligence about finding out about their borrower. So residential cash reporting is going to be required. There's no threshold amount. Any conveyance that falls within this statute, even if it's for zero, will require reporting. This takes effect December 1 of 2025. It's somewhat different from the geographic targeting orders that a lot of states have already had in large areas in Florida, New York, California, Texas. Title companies have been dealing with this in the states where it's been for quite some time. So this is not a new deal, except this one has no monetary thresholds. Primarily, just figure the person responsible is going to be whoever's handling that closing. There's a cascade of if not them, then somebody else, then somebody else. But ultimately, it's going to be whoever's handling the closing. You need to be prepared for it to get the information, and there's a lot. And it has to be sent in within 30 days, and there's going to be a website. They're working on that right now. So again, this is any all cash, i.e. not an AML bank or bank lender. So this could include family financing or, of course, a hard money lender. If the buyer is a legal entity or a trust. Now, the American Land Title Association really went to the bar on this to try to make sure that there were exemptions and that there were some practical input from the title standpoint, from the title and closing standpoint. And they did ultimately have success in excluding estate planning trusts and 1031 QIs, qualified intermediaries. So that was good. At least they got those out of there because that was going to be a nightmare. When they say residential, they also got a limit on that. That means currently it's residential, whether it's a rental or owner occupied, 1 to 4 family residential, because so that includes condos, townhouses, patio homes, or if the owner is getting a building permit for residential property. So those are the types that it's going to be that are going to be dealt with. I don't know of any developer exclusion at this point. I'll learn more about it in just a little while because I'm about to sit in on another webinar on this. It's a detailed report. There are in the draft, and you'll see down here, the proposed form is published, and the comments are due back 60 days from the 13th of November. So that's early January. There are 111 different bits that may or may not need to be filled out on this form. It includes not just name, address, tax ID numbers for seller and buyer, but a lot of other information. So you'll want to look at that. I think the Real Property Section Residential Committee may be looking at that to see about giving comment, but I know there will be a lot of comments from across the country. The rule doesn't go into effect till December 1 of 2025, so there's some time to adapt. And here are some in your materials. There's going to be some information where you can find out sort of the nutshell version, the news release, and other information about it. The Corporate Transparency Act, many of you have heard a lot about that. That's not real estate related, that's entity related. But it was part of the legislation we were looking at and tracking. And I just wanted to make sure everybody knows that right now there is an injunction in a federal court in Texas, ironically by a gun shop owner. So FinCEN has actually said that reporting is going to be voluntary under the CTA for now. until there's a final determination of whether it's going to stay enacted. And the Texas court's not the only one looking at it. It actually has been upheld in other courts. So we're just kind of waiting to see where that's going. But that's news for today on that. So what else is going on? My pet project of the day, week, month, year, is dealing with deed and contract fraud. You guys have seen, I'm sure, if you do any residential deals at all, you have seen situations where suddenly an affidavit or a memorandum or some kind of contract that doesn't comply with Chapter 47 or 47G or 47H is put on record to say this owner has contracted with me to buy this property and doesn't give you details and is not even signed by the owner. We're seeing more and more of these. And though we passed House Bill 422, which we talked about a few minutes ago, the MV Realty bill, we're just still seeing a proliferation. So we're trying to come up with legislation to deal with it. The other thing we're seeing, and I laughed when I started this, I'm sitting here drinking my Coke out of a mug of Graceland. My husband went to Graceland to test the software of their clerk's office and search their title. And he thinks that he's probably the only North Carolina attorney who's ever searched the title to Graceland until there was a deed fraud, a mortgage fraud, just recently that was in the press. I could give you a long spiel on this. I will tell you we've got a long spiel on our website. If you go to www.northcarolina.ctic.com, which is our website, and look up to the right new and events or something like that. You'll see news and events. You'll see that there's about an hour presentation that some of you may have seen. It's not CLE credit, but it's entertaining, not because I gave it, but because the stories are amazing. We gave to TaxMappers attorneys and others down east last week. So if you're interested in that, please feel free to go there and look at it because it talks about these deed and contract fraud issues and why right now we are working on legislation probably to have available mid-January as a draft, hopefully for the 2025 long session, the new long session. There have been several stories in North Carolina, and there are several lawsuits going on right now where people tried to, what they call steal deeds. Now, it could be notary fraud, it could be a forgery, but most of these cases, ironically, the person who signs really is signing their own name. They're just putting it on another piece of property. We're title lawyers, we think. So why would that be in the chain of title? Why would we care? And the reason we care is because in one case, the HOA was asked to give a key. In another case, the people actually got the locks changed on the house by showing someone they had a deed. Utility companies may take them and change the utilities. Tax offices may not really get it if they give some specious reason for it and they change the tax bills and suddenly you don't know about it. It can have a lot of negative effects on people. So there's a lot of collateral damage that can be done, even if you want to argue it's outside the chain of title. So what we're planning in the legislation is to make it clear that, number one, try to provide some mechanisms to prevent the things from being recorded at all that shouldn't be. Give the register some other lever, some other tool to be able to stop them if they're not comfortable they should be recorded. Now, we have 100 registers, a lot of different variations in experience, understanding of title. But the one thing they don't do is search titles. Those of you who've seen the articles in Raleigh will know that that was something that was pushed to the legislature, like, well, why doesn't the register search title? That's where we're recording our documents. We know that doesn't happen here. So we're trying to provide other tools to give penalties, treble damages among and stiffer criminal penalties if the fraudster does do it, does get something recorded. And finally, give some kind of, well, not finally, give some kind of affirmative provision under our recording statutes, 4718, 4720, and various related statutes, that if a document gets signed and it's not signed by an owner, that it has no constructive notice, the affirmative statement to help us. It doesn't prevent the fraudster from going through. I asked about getting a gatekeeper order, but we really don't have a state statute for that. And on the back end, the fourth piece, which is the first one here, an expedited curative procedure for innocent landowners who have had these kinds of fraudulent documents put on their title and they need to clear the title to be able to move forward. So those are the basic components we're looking at. I've got a whole lot more details, been a lot of research. We've got an email group of probably 40 or 50 people at this point, and more looking in. We're trying to gather all the stakeholders to look at this so we can come up with a solution that will work with the courts, with the counties, with the cities, with the registers, with the tax mappers, with the tax offices, et cetera. And some of this, the fraudulent documents, I mean, are UCCs. A lot of you have seen those common law liens, UCCs, things that just don't fall within our statute. I think I almost, something dropped down. I know there are a couple of comments in the chat, but I don't know if anybody, I can't get to them.
Nancy, Lewis Fisher asked, and I was going to ask Lewis for clarification. He wanted to know about if there's been any discussion about repealing the current federal FinCEN Act, and didn't know if he meant CTA or the other, and the upcoming Burdensome Disclosure Act. Both components require some disclosure.
Who knows what's going to happen in January? I mean, who knows? That's back to my not having a what do you call it, a crystal ball about what's going to happen. I've never seen anything quite like it.
But one thing we've talked about though, Nancy, I mean, I think that seems to be, and certainly you have your finger on the pulse for this. It seems like the trend in our state and the trend nationally may be to continue, whether it's this, version of FinCEN regulations or something else in the future. The trend seems to be to try to counter foreign investment, foreign ownership, that sort of thing, money laundering, criminal activity and transactions.
Yeah, and I will get back to that part of it in a minute, because we can almost certainly foresee that there's going to be some kind of foreign adversary additional restriction in addition to the high purity quartz as opposed to quartz, which is what we're going to talk about now, quartz. The conversations get kind of interesting. But I will get back to that. Thank you. Enterprise justice, you now all know this is going public as fast as the speed of light. All of the courts should be on by October 2025. And then the business court is going on. Business court has a great system already, so that's disappointing, but it will be there. Now, I will say I have my days when I like it because I can find things on record now online. But other days I don't like it. We have some claims already. situations where either what was brought forward in estate files was incomplete or not appropriately labeled, and there were ambiguities which created problems, or things have not been findable because the search system is so different from VCAP, so different from VCAP. Very good attorneys have not been able to find things or have missed things because it is so different from VCAP. So that's the schedule. This is straight off of the eCourts website. I will tell you, if you haven't already done it, the minute you're going to have to start searching in a county with Portal Enterprise Justice, you really are going to have to make sure that you and everybody who touches any kind of searching is studying what's the instruction information that's on the Enterprise Justice, the NC Courts, eCourts website, as well as studying what Matt showed you earlier. The NCLTA has posted both the Return to the Vault recordings by Terry Bowling, who's been involved in this since the beginning. I mean, she was meeting with the AOC before this even went live and even before the first time it was deferred. And we'll have an updated set of her materials shortly. She has done an update for the Cape Fear group that she's doing her presentation for today. And hopefully we'll have a recording of that, but for sure we'll have her updated materials. She's already offered that. Here's the website where all these are posted. You'll see Matt's face there. These are the two recordings that are on there from earlier times. And these are after it went live. There were some earlier ones as well, but these are right down in the weeds. And these are the materials that went with them. Again, these are not the official materials. Go there first, study those, but these are the practical people who are actually having to use the system type input, because we've been sending every question we get to Terry for the last 2 years. And poor thing, she's held it up. I don't know how. So these are a lot of the questions that are coming up still, but I'm not going to go through these because I want to move a little bit on. We've got more slides to get through. This affidavit was developed by the Land Title Association. It is for two purposes. As far as the seller's concerned, it's what in most states you would call a title affidavit. They're saying they haven't done anything and that would affect the title, but also verifying that because of the concerns that you may not be able to find anything on the Odyssey portal. So this is really to protect you on that side of it. The current owner saying, I haven't done anything, you didn't find anything, and the reason you didn't find anything is because I haven't done anything. So that's an affidavit indemnity to protect you and your purchaser or lender. The flip side of that is it's also a disclosure, which is to protect you and your client in understanding that there are limitations to the system that you can't give the type of assurances you would have given on VCAP. We're not to the point where there's a standard of practice on this yet, where we know what's right or wrong, where we know what the Phillips v. Hennant case is going to come out on, where we know how to find entities with acronyms reliably. So again, this was developed by Land Title for those two reasons. The General Statutes Commission, if you don't know who they are a group from the Attorney General's office, the drafting group, but it's a statutory appointment from several law schools. They just added one for Elon, from several law schools, UNC, Wake Forest, each law school has an appointee, plus several practitioners from different areas of practice. And they look at all uniform acts. They also get dockets for various things from various groups. because what they are really good at is looking at statutory drafting, coming up with what's the best way to say it consistent with statutory drafting in the state. Who are the stakeholders that they need to talk to about it? So if they open a docket, they're actually going to reach out to a lot of different stakeholders. They're going to listen to things and they will deliberate, and it will take quite some time. Typically, they only meet once a month. But all uniform acts come to them to make a decision whether there are, and ask the question whether there are stakeholders who want to deal with the acts. The two that they have right now, but that are also in front of the Bar Association Legislative Advisory Committee today, are the Uniform Community Property Disposition at Death Act and the Uniform Electronic Wills Act. There's going to be a North Carolina version of each of these. The real property section, and I'll give a shout out to John McLean. The real property section gave input on the Community Property Disposition at Death Act to make sure that if property is to be treated as community property, real property, by a husband and wife, they've moved here from, say, California or another state with community property, and they're replacing that property from there with property in North Carolina, and they want it to be community property. It has to say that in the public record that you will search. So when you are reviewing in detail every document in your chain of title, you will see a provision there for it to be community property if that is their choice. The Uniform Electronic Wills Act is very complicated. I'm not going to go all through it, but it was heavily vetted, and it really tries to address both security, complying with our laws, but also, and it does not allow for remote electronic notarization at this point because our statute still isn't final. But it does allow for a digital will and deals with how it would be dealt with by the clerk. And of course, now we have e-courts, so that makes perfect sense. This is one last big one I want you to know about. It's going to come back again. This is what Matt was talking about these bills to prevent sale of property to an entity that is owned or controlled by a foreign adversarial government. Now, you'll remember the 6 that we talked about back in the quartz, high purity quartz case. Those would be probably the same ones they're going to have if and when this bill comes back again. And notice, it will require, that statute actually voids the transaction. You don't even know it's void. It just happens automatically. So we've gone and tried to convince the legislature what they should do is what other states do, which is have a procedure to declare it void if in fact someone proves that it violates the statute. Think about this in North Carolina.
Yeah, just think about if you're a title examiner and you see a transaction, a conveyance to entity LLC, and if there's not already some proceeding to void that transaction. And by the way, I mean, are you gonna? That begs the question whether every time you see a transaction to an entity that, you know, particularly if you know about where that property is in relation to a military installation, are you then going to have to be looking to see if there's been a proceeding to have it invalidated, if that even comes, if that part of this even comes about. But I mean, you would not know as a title examiner.
Right. And if it's void, is that the last transaction or the one before? I mean, 10 years from now, how will you know? And this is the one that's really scary because it's all land within 25 miles of any military installation. And it lists all of them here. And there's been more added, and any facility located within the state that is subject to the installation's oversight and control. That comes out of the federal statute. Understood. But I don't know what that definition means. And it includes any agricultural land. So how much of this state is going to be subject to this statute? I would submit probably just about all of it. And again, it refers back to 15 CSR 7.4, but it's now 7.941, which are those 6 governments that we just looked at. For now. This one hasn't passed yet, but again, we went back to try to say, make it voidable, make some kind of procedure where everybody would know if someone is claiming that there was this foreign adversary in the background of this entity that took title, so that third parties, lenders, and purchasers for value and sellers could be not held liable for having dealt with the property. I mean, you think about, how do you unwind that? If the seller's loan's been paid off with these foreign funds, do they get the property back and their mortgage paid? I don't know. That might be a sweet deal. So one of them was Syngenta. You may know that Syngenta just opened a whole new big facility here in North Carolina. Well, they are owned by the Chinese. So anyway. So here's the outline of this, and I am now out of time, I think. So this goes back to what we talked about before. Last item, there's going to be more community association stuff. Matt's going to shake his head, absolutely. So now 20 lucky people are going to get an email from me, I guess, that they've won the
Yes,
drawing.
and Nancy, I can announce those names, or you can. Sherrard has emailed those to both of us.
I don't have my email up, so you go for it.
Okay, and let me I will take over retake over the share here. All right, so any questions or comments? I know we did have a few that came in on the chat box. I think we addressed those. Anybody who missed it, just as a reminder, be on the lookout for the in case you missed it email. It'll include a recording of this presentation and all the program materials. Also, if I got a couple questions about the link for the drawing for the Hurricanes tickets. If you'll email me, I'll make sure you get that link, or also I'm sure it'll be sent out once or twice more from Sherrard and the NCBA. They're the reminders of the upcoming programs that we mentioned earlier. And then again, here are the prize winners. Nancy, I can read those off as we've just discussed it. Do you want to say anything about Chicago title first?
We love you all, and we really appreciate when you learn about what's going on and do such a great job. And thank you for joining us today.
Well, and Nancy, I want to thank you too, on behalf of all of us and in attendance and our section and this program, for having you here. I'm, in my time involved with the section, in the little bit of tracking the legislation that goes on downtown here, that I have done and been involved with, working with you on that as part of our roles with the section. It is a monumental job, and so I hope everybody here, I think everybody recognizes what amount of work you put into this, and we really appreciate it. There's always a lot going on down there. So with that said, here are the drawing winners, and Nancy or someone from Chicago Title will be in contact with all of you that I'm about to name. Monroe Pinnell, Adam Hall, Susan Elliott, Lisa Logan, Ashley Ray, Aaron Catlett, Al Sellers, Alex Pascal, Robert Douglas, Terry Jones, Virginia Burrows, Crystal Mann, Lisa Bullock, Brandy Ferrentados, Janet Stedham, Sarah Page, Deborah Sperati, Patricia Moylan, Robert Hood, and Kim Rosenberg. Congratulations. And thank you for attending. Thank you, everybody, for being here with us. And we will see you next time.
Happy holidays.
Yep. Happy holidays, everybody. Thanks.